Before them official pa Emma akwa baba channel we su bi ye bompa ye say afisisi na nyoma ekoyi ma na wote nkwam ho ahoɔden wɔ apɔmuden na bibia wɔde nsa ebesom bia eye nhyira ɛma wo ne wobusuafoɔ ne wadɔfoɔ nyinaa ɛna Ghana man nyinaa ɔyɛfo sɛ mbɛka ya yɛto aba wie 9 constituencies bi wɔ ha asɛ na mente me ho ase bi ɛkɔ so ɛwɔ hɔ we na yi si ba out or say Re-Collation no ɔdɔfoɔ NDC foɔ bebree na ampene but akyire yi si ɛkɔ so a ɛyɛyɛ ɔyɛɛ no 7 out of 9 no ɔde ama NPP foɔ na we na NDC foɔ si hen ha ɛna NDC foɔ de akɔ court a sisi a court Supreme Court say yo obeti asɛm no so nti nyame yɛ adom a on the 27th of December ɛna ɔde mmuayɛ no ɛbɛba which means if you are the ɔdɔfoɔ so mɛka ne sɛ NDC foɔ ɛyɛ ate asɛmpa mommɛnkɔhwɛ video no a sɛdeɛ nkyerɛkyerɛ mu no ɛsi kɔɔ so ne kwan a NDC foɔ ɛde kɔɔ court a court agye atum sɛ ɔbɛhwehwɛ mu no mommɛnkɔhwɛ video no ɛmbra sisi a.
Okay, so this is definitely one of the biggest news for the National Democratic Congress right now, because all of us were wondering, say, after the Re-Collation, about 7 out of those 9 contested seats, Ekodi MPP Fuafano, what was the game for the National Democratic Congress? Remember, say, some
this is Again TV.
In the party, they were so much angrier. Some of them even wanted to storm the Re-Collation exercise. But other, if he John Dramani Mahama, Eba, say, no one should storm there, and until people did not storm there. So afterwards, we were wondering, so what is really next? You see, in Kitia Kacha is a more master plan, and clearly from the announcement and the news about to just see, it is hinting or telling us that this particular master plan has already started. I didn't make us the same way. Currently, we know say in the breaking news about this particular Re-Collation the EC did out of the 9 contested seats so far, a very controversial. 7 Ekodi MPP for currently, as I'm speaking with you, the Supreme Court in Simbia Babe Tuja. Now, this is coming from Daily Graphic, obviously, as you can see on the screen. It says, Re-Collation saga, Supreme Court to hear NDC's application December 27, which means Yamebua Echna, which happens to be more like a Friday. And the Supreme Court but national NDC for application for the Supreme Court. Now, the reason why this is so much a good news for the National Democratic Congress is that EC I don't even know how to put it. Let me break it down. In 2020, EC the new rule be by your friend is CI and a new law or more amended or more a constitution or the new law be by your friend new law CI 127. Now CI 127 in the EC's rules and in the EC law EC air patches say Re-Collation yenti mean Re-Collation after say yabobo results, which means that we can only do Re-Collation before we announce the results. This was amended in the 2020 EC Constitution. I find CI 127. So if we are going by the Constitution and the playbook of a Electoral Commission or more amended laws now, which means this particular Re-Collation either as a court ebe brogu and now court ebe say we should go and have a new elections. Secondly, I'll be breaking this down for you to understand where this one is also heading. Secondly, EC argument or the two social media and no reply NDC for John Dramani Mahama is saying Kiti and Sami JV and allegations by say EC now say they are working for the New Patriotic Party. EC argument on the by almost citing records of a year Farijan any a year other past members like Charlotte Osea. Basically Re-Collation of course during their tenure, but those cases were 2004 2008 and before a friend is in the tenure of Jemensa. Now Jemensa 2020 she amended the laws and on the CI 127 so everything that happened before CI 127 ain't me for because a past sentence the new law are into effect is stated just one thing. no re-collation after the results have been made. A chair said re-collation can only be done before the results. And as before both parties ABR or agree. So re-collation, you announcing results anywhere. There's no re-collation according to the electoral commission one brano. After the announcement of the results, no re-collation, and any party be out say law no and as elections no we need to go to court. So ideally the parties which was supposed to be the EC and the New Patriotic Party, they were supposed to go to court to halt the process and as a demand for another re-election and as a re-collation and as a by-election. Now, we check the body of this because there is a twist to this. I'll say the Supreme Court will on Friday, okay, the 27th of 2024, sit to hear the National Democratic Congress application challenging the High Court's decision to ordered the Electoral Commission to collate and recollate the parliamentary results in six constituencies. Now, basically, in this, just telling us the Supreme Court sits on this particular case. Again, an Accra High Court on December 20th ordered the Electoral Commission to bring finality to the election in 6 constituencies by collating the results and declaring the winners the winners in tandem with the electoral laws of the country. Again, the 6 constituencies were Tema Central, Nsawama Dweji, Ablukuma North, Ahafuano North, and Techiman South, and Okwaike Central. Apart from the order to collate the results and declare the winners, the court presided over by Justice Reverend Joseph Edu Owusu Ajiman further ordered the Inspector General of Police to provide EC with adequate security and recollection at the recollection centers to enable the commission to discharge its duty. So basically, this was a year High Court ruling some time ago. But then CCR, even though a year NDC for the application a High Court say anka omu halti recollection, the court subsequently ruled against them, telling them that the EC should go ahead and recollate. Yati no say, but HNEC follow the court's orders to recollate, and no NDC for Asandiako Supreme Court say based on the law, a year CI 127 EC does not have the necessary permission to do another recollection because the law nature said you can't do recollection after the results have been made public, and any other grievances beyond after the results have been made public, it should go to court. So this is the master argument, the National Democratic Congress going further, going further into a Echinichi Friday. Our courts, Supreme Court, this is the argument of making. And one person currently also didn't know about to same air something lawyer, sounds so TV host our joy news. Or Pacha say the High Court ruling a year or more allow for the recollection after this particular recollection, all the results for some reason, weird reason, it is going in favor of the New Patriotic Party. How? Ama a move 7 out of 9 echo. Aquama the New Patriotic Party ebra 2 akano and no the pink sheet crying into the officers said they will not mention it. Isn't that concerning? So based on this, something you need a party say people have gone to school or minimum law. Yet I said the Supreme Court judge almost law, so that is why they're on the bench. But that ruling which came from the Accra High Court allowing the EC to do recollection, it is void. It is void. That is what something in some of the Bible to journal. Now, you could see what he said in his entirety. The
law says also that once the gazetting has been done, within 21 days from the date of the gazette, anyone who has any complaints about the process must approach the High Court. I repeat, High Court, not the Electoral Commission. CI 127, on the basis of which the NDC insists that recollation is unlawful, is spot on. They are absolutely right to say for all constituencies where collation has already taken place, there cannot be recollation. Now check CI 127. you will find that there is no mandate after the returning officer or an officer so appointed who has made the collation and the declaration. There is no room for re-collation and re-declaration where the collation has been done and the declaration has been done. Now, Raymond, check the Act 284. At 284, let's look at specifically Section 20. Section 20 concerns grounds for cancelling election results. This ground must be canvassed in a court, not before the Electoral Commission headquarters. So it says these are the grounds: general bribery, general treating, general intimidation, or other misconduct or circumstances, whether similar to those specified in this act or not, have so extensively prevailed that they may be reasonably supposed to have affected the result of the election. That there has been non-compliance. Raymond, mark that.
Okay, non-compliance.
About what? Non-compliance.
Non-compliance, right? Anyway, yeah.
That there has been non-compliance with a provision of this act, or, mark that again, or the regulation, and that it appears that the election was not conducted in accordance with the principles laid down by law, and that non-compliance affected the result of the election. Or C, that a corrupt or illegal practice was committed in connection with the election by the candidate, or with the knowledge or consent of the candidate, or by an agent of the candidate, or that the candidate was at the time of the election a person not qualified or a person disqualified for election. So once a collation has happened and a declaration has occurred, my respectful view of the law, which appears to be the plain reading of the law, not that I am seeking to interpret it, is that there cannot be a re-collation. If the collation, whether it was marred by whatever conduct, as the law says, whether it was marred by intimidation, it was the result of a duress, whether or not the person who did the declaration is not qualified, and whatever the reason may be, the forum where a re-collation may happen, the forum where recounting may happen, the forum where a new declaration may be occasioned is not any place other than the High Court.
Please subscribe, comment, and share for more content.
Thank you so much for watching. Kindly don't forget to like, comment, share, and subscribe. Stay safe till we meet in the next one. I love you, and it's bye for now.